Well, we're pleased to have a representative of the Sullivan County Division II General Sessions Court, Juvenile Court. In this area, 45 years ago, Kingsport had a part-time appointed judge, Wayne Hamilton. Some of y'all probably knew him, who was involved in the funeral business. He administered juvenile justice. A couple of you guys, he may have took your motorcycle wheel away from you if you had been out violating the traffic law. But he was not an attorney, and over the years, led by Judge Garrett, the courts merged, and since that time, Judge Jones and now Judge Mark Toohey serves as a juvenile judge in Kingsport. I think Bristol still has its own juvenile court, but the rest of the county, the juvenile court services are delivered by the General Sessions courts. We have with us today Mandy Whetsell, who is the Assistant Director of the Juvenile Court and has been with that operation for over 25 years of juvenile justice. She's a graduate of DB, ETSU, having criminal justice and criminology degrees with minors in political science, and something that probably helps her a lot in her job is religious studies. She's married to Steve. They have 2 adult children. We're on the way. And the other thing, for some of you guys in here, and ladies too, she teaches a hot yoga course. So if you're interested in that, you can see her after the show here. So Mandy, come forward and tell us about the juvenile court dynamic operation.
Thank you. So you have to forgive me, I'm not the best public speaker, I'm sure, especially trying to do 10 things at once, holding on to this and read. So it's a work in progress. So juvenile court in Sullivan County, we have 2 divisions. We have a division 1, which is going to be what we call Bristol County. It's Sullivan County on that end that's not in Bristol City. Then we have our division 2, which is here. We cover all of Kingsport, all the way up to the Hawkins County line, and then we cover up to about where East Lawn Cemetery is. That's typically kind of our marker. Anything that's just on the other side of East Lawn, it's kind of a gentleman's agreement that we'll sometimes handle those, and then sometimes we'll go ahead and send them up to the other end. Bristol City does have their own judge. It's typically Randy Kennedy. I think he holds court once, maybe twice a week, depending on what their caseload is. So here in Kingsport, we have 2 probation officers, and of course myself, the assistant director, Greg Walters, the court director, and 2 secretaries. We are all full-time and could probably use a couple more probation officers if we could get some funding for it. But we do not have a full-time juvenile judge. I don't know that we've ever had a full-time juvenile judge. Judge Mark Toohey handles the majority of our juvenile cases. He is still a part-time juvenile judge and full-time sessions court. Ray Conkin is also a sessions judge, and he handles cases 2 afternoons a week for juvenile court. Then we have Jeff Luthke, who some of you may know. He is our magistrate, and he hears cases 2 to 3 times a month. Whoop, wrong way. See, I told you. There we go. So what is juvenile court? Juvenile court is a specialized court. We handle cases that involve minors, typically under the age of 18. Some cases can go up to the age of 19, depending on the offense and the situation. Our primary goal is always rehabilitation over punishment. This says that generally our proceedings are more informal. They are slightly informal compared to adult courts, but it's still a very similar process. We address delinquency, unruly status offenses, and DNN cases. So delinquency cases are cases that are criminal matters. It can be anything that an adult or a juvenile could commit. We would say theft, robbery, anything like that you could be charged with, so could a 15-year-old. Our status offenses will be things that only a minor can be charged with, being unruly, being truant, runaway, those types of things. So, and of course, DNN cases are our dependency and neglect cases. So our theme, if we have one, is always going to be operating under the idea that we're here for the best interest of the child. So every decision we make will typically, even in our court order, state this is in the best interest of the child, or this is what the court sees as would be in the best interest of this child. So some key aspects, we do focus on rehabilitation. That's our main objective. Our whole point, if a child comes into the court, especially for a delinquent or status offense, is to rehabilitate them and get them to a point that they won't come back. You know, not everybody in this room, I'm sure, but plenty of people in this room probably did something stupid when they were kids they could have gotten in trouble for. Maybe didn't, but could have, right? So I see a few heads nodding. Most of you all were really, really good kids that never did anything wrong. Okay, that's what I thought. So our goal would be if you just did something really dumb, you know, something really stupid, and you come in and we work with you on it, whether it's counseling, whether it's a family situation, you know, whatever your issues are, as long as we address those, you finish out your probation, finish out your program, then you go away and we never see you again. Okay, we like to tell kids, I hope I never see you again unless it's in the Walmart or at the Target, right? Otherwise, we don't want them to come back. So we are different from adult court because the proceedings are slightly different. We have the delinquent offenses, and we refer to them typically as delinquent offenses and not criminal acts. Juveniles have most of the same rights as adults. Their records are also often sealed to protect their privacy. So for juvenile court, everything is going to be confidential. We don't release the files even to the parents. You can have copies of court orders and motions, and that's it. The rest of it stays with us. And then, of course, most of the files are expunged at some point. Let's see our jurisdiction. As it says, minor offenses to serious crimes. Anything an adult can be charged with, we can also deal with that in our juvenile court. The dependency, neglect, custody, visitation, all of those matters are handled too. So the process, we start with a referral of some type. If there's an unruly child or a truant child, typically we'll get a referral from either the parent or the school system saying, hey, this kid has missed 15 days of school this year. We've gone to the home. We've tried to work with the family. They're either compliant or they're not. They need some extra services. At that point, depending on the situation, we'll either bring the case before the court itself or we'll do something that we call a referral for services. Family Crisis Intervention Program, referred to as FCIP, that goes through DCS. And they'll go out to the home, meet with the family, meet with the kids, see what's going on, and make a plan to try to work on the situation. Sometimes kids are truant because they're refusing to go. Sometimes kids are being bullied. Sometimes there are anxiety, medical issues, what have you. Oftentimes, when FCIP goes out to the home and makes a plan, they're able to get them back into school, whether that involves services or just getting an alarm clock for this kid because mom or dad have to be at work at 5 a.m. and they're just not getting out of bed, or helping with cars or bus services or something like that. Let's see, interventions. Instead of incarceration, of course, we try to do things like community service, counseling. Sometimes we have to look at foster care placement. That is usually our very last resort to bring the kids out of the home. Again, confidentiality, proceedings are closed to the public, and we do seal records. So in very serious cases, a juvenile may be transferred to adult court or tried as an adult. We do that. It's not something we do very often, though. So again, our judges, Mark Toohey, he's our main juvenile court judge. He will hear cases Mondays, Wednesdays, and Fridays. And Friday mornings are typically when we do our arraignments. So anyone that's been charged with a crime, unless they are held in the detention center, which is like the juvenile jail, they'll be set for arraignment when they'll come in just like adults would and enter a plea, guilty, not guilty, and set things for trial. So we typically do those on Friday mornings. Ray Conkin, he hears cases 2 afternoons a week for juvenile court, Monday and Wednesday. And of course, Jeff Luthke, he is a full-time attorney, so he only sits with us 2 to 3 times a month. So again, delinquent, any crime committed by an adult, the drug offense is theft, even something as terrible as murder. We have jurisdiction until age 19. We can keep juveniles on probation until that time if necessary, or stay involved with the family depending on the offense. Our dispositions can include an informal adjustment, which is typically when you would come in and meet with someone like Mr. English or Ms. Presley, one of our probation officers, and go over some rules and regulations, things that the children or child would be required to do for about 90 days. And as long as they do that and there aren't any major issues, the case will be dismissed and expunged. And those are only for certain offenses. Judicial diversion means the child came before the court, entered a plea of some type, and was placed on 6 months probation. At the end of that 6 months, they can also get their record expunged. Indefinite probation is typically 6 months, but can go longer. That usually comes after there's been an informal adjustment and a juvenile a judicial diversion, and maybe a probation violation and so forth. And then state custody would be when the child is taken into the custody of the Department of Children's Services. Oftentimes they are placed in a group home or a facility or a rehabilitation facility. So as far as our juvenile detention, we have one juvenile detention center in the Tri-Cities area, that is in Johnson City, the Upper East Tennessee Regional Juvenile Detention Center. And we can hold juveniles there for up to 24 hours for an unruly status offense if they're a danger to themselves or others. Otherwise, juveniles may be held in the detention center for up to 48 hours, excluding non-judicial days, holidays, weekends, things of that nature. We tend to have arraignments for kids that are held in the detention facility the next morning instead of waiting until a Friday. So if a juvenile gets in trouble on, say, Friday night and they go to detention, they'll be there until Monday morning. And we'll usually handle those by Zoom so that the child doesn't have to be transported. There's a lot less risk involved with that. So delinquent transfers, this is something people ask us about a lot. How often do kids get tried as adults? It's not as often as the movies like to play. You may have watched Law & Order and think that every time a kid over the age of 13 gets in trouble, they're going to the big jail, the Hooskow, and that's not really how it works. It's very infrequent. But if a juvenile offender is 16 or above, they may file a motion to transfer the juvenile offender to adult status. Typically, the charges have to be first or second degree murder, rape, aggravated rape, rape of a child, aggravated rape of a child, aggravated robbery, or an attempt to commit such felonies. The thing with transfers, we have to have what the TCA calls reasonable grounds. So often what the judge has to look at is, does he believe the child has committed the offense? Are there reasonable grounds there for that? Is the child competent to stand trial? If a child is being transferred possibly to an adult court, we will have a competency hearing, and they will also have an assessment to determine whether or not they're competent to stand trial and should be able to be transferred. We also have to consider the interests of the community, and typically if a child's being transferred to adult court, they will be held in the detention center until the time of their trial. So the court has to consider the child's prior delinquent record. Is this the first delinquent charge they've ever had, or do they have a long list? Past treatment efforts and the response to treatment. So if we've tried multiple treatment modalities and these juveniles have done well with them, that's a positive. But if we've tried multiple treatment modalities and they've not done so well, then that could always be a negative. Was the offense against a person or property? Of course, greater weight's going to go toward person. Whether the offense was committed in an aggressive or premeditated manner, was this something that just happened, or did they plan it out? Possible rehabilitation services available. If we have a facility that this child could go into, is there a service that might help them more so than putting them in the adult system? And whether the child's conduct would be a criminal gang offense as defined in TCA Code 403512 if committed by an adult. So a status offense, again, these are charges that are only applicable to persons under the age of 18, such as the truancy, possession of tobacco, which we are overrun with tobacco and vapes. It's constant. Unrulies and runaways. Jurisdiction until the age of 18, and again, disposition can be lots of things. Indefinite probation, informal adjustment, FCIP. A take charge is similar to state custody, but not as severe. So if a child comes in and let's say we have a child come in and they don't have a legal guardian, but they're staying with their aunt or their uncle or their grandparent or something along those lines. And maybe they get in a little bit of trouble, but they don't really need to be moved from their placement. Oftentimes we'll do something called a take charge, where the Department of Children's Services will take charge of this child and investigate where they're at, where they could go, or do we need to look at a non-custodial facility, and they'll determine where the kids need to be placed. So what is juvenile probation? A juvenile probation officer will supervise youth on probation for typically a period of about 6 months. They'll have a long list of rules that they have to go by. Curfew, typically we start kids out with a curfew of 8 p.m. So they have to be home after 8 p.m. or they have to be within arm's reach of their parent or legal guardian after 8 p.m. The only exceptions would be if they're playing in sports, if they have a job, something along those lines. They have to obey their parent. They have to go to school every day, can't have any unexcused absences, and no more charges. Those are kind of the gist of it. While on probation, the officers will go out to the home. They'll make unannounced visits, sometimes announced visits. They typically go through their room to make sure there's nothing in there that's inappropriate. I cannot even describe to you some of the things that we've found when we've searched kids' rooms that parents had no idea was in there. It's been interesting, really. They'll administer drug tests. We do urine drug tests, and the officers will supervise those. School visits, typically they go out to the schools at least once a week. We don't often have kids in elementary school that are on probation, but it has happened. So mostly they visit the middle schools and the high school. So their duties are writing their reports. They perform a risk assessment to determine what could help this child. What is their risk level? Do they need a high level of treatment, medium, low, and so forth? They also put kids in contact with lots of community resources, and sometimes that's community service based too, and they maintain some detailed case records and files. So supervision, again, regular announced, unannounced visits to homes, schools, and workplaces. As far as assessment, they'll perform the risk and needs assessments to determine what level of supervision they need. And each time that a child's placed on probation and they do this assessment, they determine what level they need to be on. So level 1 has a lot more supervision than level 2, level 3, and then release. Rehabilitation, guidance and counseling to help kids and their families with, is it a family situation? Is it a drug and alcohol problem? What is the issue here and how can we help work it out? Case management, of course, they're keeping records. We have a system that the whole state is compliant with now called Quest. Everything goes in there. They monitor compliance with the court orders, conditions, whether they're obeying their parents and so forth. And of course, public safety, trying to keep the kids from getting into any further problems and trouble. So dependency neglect cases. These are typically protective cases when kids are at risk of dependency and neglect. So if a child's being subject to abuse, neglect, or is in danger, they may come in on a dependency and neglect petition. Typically, the Department of Children's Services, one of their attorneys, will file a petition for children, or an individual can come in and file. So if I had a sibling who had a child and I knew that my sibling was had problems with alcohol or drugs, or they were not taking care of the child, I could file a dependency and neglect petition for my niece or nephew or what have you to ask the court to give me custody until mom, dad, or whomever were able to work out the situation. So if allegations are sustained in court, along with the case manager, they will create a treatment plan. We call it a permanency plan or a PERM plan. And it's a plan to get the child back into permanency, out of foster care or out of any temporary placement that they're in. If that does not work out, worst case scenario would be what we call a termination of parental rights. So, is that video?
Does the juvenile court have jurisdiction over parental rights cases?
It depends. Such as if you're looking at, a lot of people will confuse parental rights with visitation and custody. They're not necessarily the same thing. So, but when we do some questions at the end, we'll go over that if that's okay.
I don't have to say it.
Oh, okay, that's all right then. I'll blame Jason for that since he did this. So, other responsibilities of the court, we serve on various boards. We call it SIPIT. It's the Child Abuse Prevention Investigative Team, where the Children's Advocacy Center, Department of Children's Services, other community service providers, the District Attorney's Office, KPD, Sheriff's Office, they all meet together and go over all the cases of abuse that go through Sullivan County. We also have the child fatality team. If a child dies in Sullivan County, that death has to be gone over by a board to determine the process or if there need to be criminal charges involved and so forth. We also will attend IEP school meetings if the parents request that Child and family team meetings are typically when Department of Children's Services is involved with a family, whether it's dependency and neglect or a family crisis intervention program. They will often reach out and just have a big meeting with all the service providers, the child, the parent, DCS themselves, and try to, again, work on a plan. And of course, we assist the juvenile court judges. I say that we're cat herders. We're always trying to get the cases together, get the attorneys in the courtroom, get the parties in there, and get cases moving. So that's part of what we do too. So these are some statistics from 2024. We had 1,185 petitions total filed. Last year, we had 944. That's good. Probation cases. Out of all those cases in 2024, we had 100 cases that were placed on supervised probation with Sullivan County with our 2 probation officers. 105 cases went to the Department of Children's Services for supervision. And typically, one of the things that we look at to determine whether or not DCS will have the probation case or the county is what the offense is, first of all. Our court probation officers are the only ones that can supervise truancy and unruly. DCS cannot do that. So any of those cases will automatically go to our court probation officers. DCS can only supervise children that have delinquent offenses or have violated a valid court order and were placed on probation for that. This is 2025. We had 61 county cases and 49 DCS probation cases. We had 1 unsupervised. 95 felonies in 2024. I don't know if you can see that. Let's see, 14 aggravated assaults, 1 assault on a law enforcement officer, 29 burglaries, 1 weapon on school property, 1 robbery, 1 drug charge, sexual exploitation of a minor, 24 of those. Theft over 1,000, we had 10. Threats of mass violence at a school, 2. Vandalism over 1,000, 1, and aggravated kidnapping, none in 2024. 2025, 103 total. 18 ag assaults, 2 assaults on law enforcement officers, no burglaries, 2 weapons on school property, 4 robberies, 2 drug offenses, 8 sexual exploitation of a minor, 13 theft over 1,000, 1 threat of mass violence at a school, 6 vandalisms over 1,000, and 4 aggravated kidnappings. So misdemeanors, typically the cases that come through, as you see, are misdemeanors. It's oftentimes theft is usually a really big one, and assault. They get in fights with each other. Back when we were in school and you got in a fight with a kid, you might get a paddling or you might get suspended or something, but things are handled very differently nowadays. And oftentimes the assaults are much more severe than they were, back in my day, that I would say. So often we'll have assaults from fights. We have domestic assault is a high number also. Kids get in fights with their parents, their uncle, their aunt, their grandparent. Unlawful possession of drug paraphernalia, theft under 1,000. Lock your car doors. Don't leave anything of value in your car. And you may think that you don't, but look, that's where a lot of these are coming from. 305 misdemeanors in 2025. For these, it's assault, domestic assault, and let's see, theft under 1,000, same top 3. All right, so that's the majority of the presentation. Any questions that you have? I know you mentioned termination of parental rights, just touching on that very quickly. When we look at termination of parental rights, that's typically when a parent has failed to be able to meet that permanency plan and they're willing to give up their rights or they're being forced by the court to give up their rights, and that child or children will be placed for adoption. So that's what a termination of parental rights is. Go ahead.